So you've been arrested for DUI and charged with a Class B misdemeanor. Misdemeanor cases have a different legal process than a felony case. In a misdemeanor case, the very first hearing that you'll have is what's referred to as the arraignment. The general procedure for an arraignment is you appear in court and enter a plea of guilty or not guilty. If you hire an attorney from Schatz, Anderson, and Uday, the answer is always not guilty. Rather than appearing in court and wasting your day off of work, sitting in a courtroom for hours simply to utter the two words not guilty, we will submit an appearance of counsel and a written entry of not guilty plea in order to void the arraignment. The next step in a misdemeanor case is what's called a pretrial conference. The pretrial conference is an opportunity where you go to court, you have an opportunity to meet with the prosecutor, to discuss the case, to try to negotiate a plea deal. If a plea deal is reached at the pretrial conference, you may also enter your plea, and under some circumstances, you may be sentenced resolving the case. However, if you are unable to reach a plea deal that's agreeable to both parties, the pretrial conference then will be utilized to schedule further proceedings, whether that be a motion hearing, where we're filing motions to suppress evidence in your case, or potentially a jury trial. The motion hearing, motions to suppress, are motions made to the court. Basically, it's a legal argument to the judge requiring testimony from witnesses and evidence to be presented showing that the motion, the standard required to surpass that motion has been met. There are many different types of motions to suppress depending on the type of case, and particularly in DUI cases, we often have motions to suppress evidence or testimony based on Fourth Amendment search and seizure issues, whether or not the officer had reasonable suspicion to stop, probable cause to arrest, whether there was an illegal detention. There may also be Fifth Amendment issues dealing with statements and self-incrimination. You may also have specific issues in DUI cases dealing with the suppression of a breath test or a blood test. Those will all be handled at the motion hearing. Depending on the judge's ruling at the motion hearing, the granting of certain motions to suppress may result in complete dismissal of the case. The motion to suppress is asking the court to suppress or exclude all or some of the evidence. Depending on the evidence excluded, it may leave the prosecutor with no evidence to prove the charge and result in a dismissal. However, in other circumstances, such as suppressing the breath test, the suppression of the breath test or a statement of the defendant alone may not result in full dismissal of the case, but simply may give a better opportunity to try to reach a more favorable plea agreement or give you a better case to take to trial. If you're unable to resolve your case or get it dismissed at the motion to suppress hearing, the next step is to set the case for trial. In the state of Utah, you have the option of doing what's called a bench trial, which means the judge hears evidence and decides the case, guilt or innocence, or a jury trial, where the jury hears the evidence, the judge conducts the trial, but ultimately the jury decides whether or not you're guilty or innocent of the charges that have been brought against you. Most DUI charges are tried to a jury. In the state of Utah, you have the right to a 4-person jury on a Class B misdemeanor, a 6-person jury on a Class A misdemeanor, and an 8-person jury on a third-degree felony DUI. Certainly, at trial, you have to be proven guilty beyond a reasonable doubt, and it requires a unanimous verdict in order to reach a conviction. If you are convicted at trial, you then also have the option to appeal from the Justice Court to the District Court and basically start the case all over again. It's called de novo review. Our goal ultimately is to resolve your case in the first court where it's filed, either by resolving it with an appropriate plea agreement or by getting the case dismissed by motion or at trial.